Welcome to Embracing Autism IRL. Today, we're happy to connect with Estates, Trust, and Probate Attorney Adam Abramowitz. A sincere desire to help people protect their loved ones inspired Adam to focus his legal career on estate planning. He believes estate planning is an ongoing, lifelong process, and he works with clients to see how each decision they make will fit into the overall picture of their long-term plan and goals. Adam is dedicated to assisting clients with all aspects of estate and trust planning, including the use of trusts for the next generation, charitable gift planning, special needs planning, disability coverage, and estate and trust administration. Adam, thanks for being here.
Thank you for having me.
Absolutely. So before we dive into the specifics, can you just share a little bit about what inspired you to focus on estate planning and special needs advocacy?
Absolutely. I think, a lot of people hear lawyer and they think about the doom and gloom of being a lawyer and being in a courtroom and fighting. And interestingly enough, when I went to law school, it was for the opposite reason. It was to help people. And so this was the perfect field to go into for all aspects of helping people, including those that need special needs trust, supplemental needs trust, things of that nature for generations to come.
Actually, that's funny because my sister's a lawyer and she got into family law for very similar reasons. So, yeah, similar story. I wanted to ask you, the topic that really sparked my interest was specifically conservatorship. I feel like it's a word that's kind of thrown out there, but a lot of people aren't really familiar with it and what it means. So I wanted to ask you, from your experience, how does conservatorship apply specifically to individuals with autism, and what exactly is it?
Sure. And I think people are hearing it thrown around a lot because it's been in the news lately, often with some famous people being subject to conservatorship. So it's a good topic to have. Conservatorship gets thrown around with terms like guardianship for individuals who need some sort of legal arrangement, legal framework to help them manage sometimes day-to-day affairs. Sometimes it's personal matters. Sometimes it could be medical. But any wide range of issues that someone needs help. And what it can be is a court-appointed individual can be named as a conservator to help limited reasons, or it can be more general. Like I said, it can be someone that needs day-to-day paying of bills and getting from place to place, whether it's medical appointments or going to a bank, things of that nature. And so it provides that framework where a judge will appoint someone and they will be available, again, sometimes for limited reasons and sometimes for more general.
So when it comes to autism specifically, what sort of factors would determine the need for one?
So I think it can be tailored to the specific needs of the individual. Sometimes they look to whether there are day-to-day needs in terms of independence. Is the individual independent? Can they live on their own? Can they complete their activities of daily living? Do they have social awareness to get through different circumstances throughout the day? And there can be more of a sliding scale of different needs, whether it's helping with informed decisions, paying a certain bill that comes in the mail, or if it's schooling, or if it's a job. And there is a wide range of evaluations that happen, again, on a medical basis, on a financial basis. It can be housing arrangements. So it's one of those concepts that truly can cover anything. It just depends on the particular circumstance. So there is certainly not a one-size-fits-all approach. And if someone is high functioning, it could be a very limited reason of simply going like an advisor. Or if someone needs more day-to-day or circumstance help, it can be someone that lives with them or is there 24/7.
So you just listed a bunch of different examples. That implies to me that there must be different types of conservatorships or different levels of conservatorships. Could you walk me briefly through what those distinctions are and perhaps how parents of autistic children might be able to decide which type is appropriate for their situation?
Sure. And I think it walks hand in hand with estate planning in general, where you can have more general conservatorships or general estate planning where you're dealing with everything from, again, day-to-day needs, more of what people generally think about as a guardianship, where you may be living with an individual, where you might be managing their finances on the day-to-day and paying their bills and dealing with everything that may happen from waking up in the morning till going to bed at night. It could be helping them with employment contracts and getting to their employment, and any sort of appropriate services throughout the day. It could be meals. It could be getting to an appointment. All of those various things fall under what we call a general conservatorship, where you'll have an individual appointed and they truly will manage day-to-day needs. You can also transition to, as I spoke earlier, a sliding scale of needs. So if an individual truly just needs help with their financial arrangements, you can look more towards like a limited conservatorship, where perhaps the individual can function living independently, or only needs help in certain circumstances getting to a medical appointment. Maybe they're unable to drive. Maybe they are unable to attend schooling or employment on their own, so they need assistance there. But a lot of times where a limited conservatorship, or sometimes called a financial conservatorship, will come in is paying your bills, is managing those financial responsibilities to manage money or open a bank account or do all of those various things that are in a very limited role, where the individual can function on their own, but they may just need help, just like any of us might go to a financial advisor or something like that. The goal of all of this is to come back to the same concept of promoting independence to the fullest extent that it can be.
Is there an appropriate time or age where parents who might be looking into this should start that process, or at least start exploring that process?
That's a good question, and I think it can vary from circumstance to circumstance, which is also one of the reasons why I got into this. Is everybody is their own little puzzle, and it's something that you have to try to put together. And so in some circumstances, I would say that generally the conversation should start early. Just like any estate plan, you want to start early and often with planning. And that can be everything from when you have a very early age and you are the guardian, and you can start with putting things in place like financial arrangements and trusts and things of that nature, and all the way up. And I think it becomes a question of how involved and how conceptually can the individual who is the subject of this handle these types of discussions. If they are informed and high functioning enough to fully grasp all of these, I think having family meetings and understanding this is truly important, because it allows the individual to understand you're not taking their freedom away. You're not trying to govern their life as they go into adulthood, but it's more of to provide, again, little things that they may need assistance with. If it is more of a general conservatorship, as you alluded to earlier, it may be something that needs to start early, where you perhaps need a guardianship or need to take earlier actions when somebody is pre-age of 18, and that might continue on. So as you're getting to those ages, 16, 17, 18, you're starting to connect with lawyers and advisors and individuals who are in that field, because some court systems, it may take a year or 2 years to get through the process, because there is a lot that's involved in it.
Is there an age limit? Like, is there like a deadline? Like, once your kid is X age, you can no longer apply for one, or how does that work?
Generally, what you will see is that when an individual is 18 years of age or under, you're more talking about the concept of guardianship for minors and management of that kind of realm, I would say. Once you get to the age of 18, you, in most jurisdictions, and again, it varies depending on where you live, you're considered an adult. And so at that point, you do not have someone that can just step in and make decisions for you. If you go to the doctor, in theory, doctors are supposed to look to the 18-year-old and say, what do you want done? They're not supposed to look to the parent and ask that question. And so you need in place something, piece of paper, court order, whatever it may be, to allow the individual to have advisors, parents, whoever it might be, to step into that role. Oftentimes, hand in hand with this, what we see a very busy time for us is right around college time, when people are going back to school because they're turning 18. And so a lot of college-age kids are putting in place powers of attorney, medical directives. It's the same concept. You need, for an autistic individual, as they're going into adulthood, they may be perfectly high functioning, but just need someone to depend on. But the bank can't turn to the parent and say, pay this bill, or can I speak to you about a credit card charge? They can't do that without a legal framework. And so that's where it gets tricky.
Yeah, absolutely. So one of the things that people kind of get confused about when it comes to the conservatorship is what paperwork or maybe legal documentation may be involved. How does that process get started? Is it just like a simple document you sign and fill out? Is this a long, like 1 year process, somewhere in between?
It's hard to answer that because every jurisdiction might be a little bit different. But generally, in my experience, it starts with a petition that gets filed with the court. And there's a lot of due diligence that goes into that because oftentimes the petitioning party, who usually is a parent, is going to connect with an attorney, get the right advice, fill out the right paperwork, and file it with the right court authority. And then typically what will happen is there will be a process that the court then lays out where oftentimes the subject of the proceeding, the whether it's an autistic adult, child, an elderly individual, whatever it may be, will have a best interest attorney that gets appointed very often. So you'll have then a second attorney that's involved. And then oftentimes there will be evaluations. They can be physical, they can be mental, all different types of evaluations, whether it's a social worker or doctors will get involved. And typically they'll file reports as part of that process. And so then the court is going to look to who's the petitioning party. What do the evaluations say? Do they say that the individual is fully dependent on someone? What's the level? Do they say they only need a little bit of help here and there? And then the best interest attorney is going to have a tough job to represent that individual. So again, you have to look to the capacity of that individual to be able to speak to their best interest attorney and allow, maybe they have a different view on who they'd want to be their conservator. And so what gets interesting a lot of times is somebody may petition, or sometimes you see it where there's something laid out in a will if somebody passes away that will nominate someone. And the court has to ultimately make the decision of what's in the best interest of that individual. And it may be the parent, it may not be. It depends on family dynamics and all the things that go into it. And sometimes, again, depending on the jurisdiction, it can be a quick process, which we all hope for. But more often than not, it can be an expensive and long process.
So one of the things that I have heard, probably because of what you mentioned with it being all over television, is a bit of a stigma when it comes to conservatorships. I think parents are just uneasy with the idea and the term. So I was wondering specifically when it comes to being able to balance that autistic individual's rights with that need for protection, how can a conservatorship be structured to ensure that the autistic person maintains as much of their independence as possible?
So I think there are two important aspects of that. And I think when you get to the root of it, that's one of the most important questions that surrounds what a conservatorship is. One of the important aspects is it is a court process, and it's not a process by which you go to court, you get appointed, and then it just disappears and the court goes away. Oftentimes, at least in my experience, you have reporting requirements where it could be anything from financial reporting to reports of behaviors and periodic check-ins and, all of those types of reporting requirements to the court to allow them to know every 6 months, every year, what's being spent. Are things being appropriated properly? Are there behaviors that the court needs to address in terms of the conservator being there, not being there, being too overbearing, all of those types of things. So that's one aspect, is there is a court reporting requirement that the court stays involved, it maintains jurisdiction. And if it's a lifetime conservatorship, they're going to be there as that level of protection where somebody can come in the best interest of the individual who's subject to it and challenge what's going on if there is misuse. So that's one aspect. The second aspect is just because you have a conservatorship that's granted on day one that may be a general conservatorship does not mean the individual can't mature and grow and exhibit different behaviors where, again, that sliding scale comes in, where maybe day one it's a general conservatorship, but then 6 months, 5 years, whatever it may be, all of a sudden the individual is more independent. They can do their activities of daily living. They can live on their own. And maybe it becomes a more limited conservatorship that somebody goes to court and adjusts it. And so I think those are two important aspects where it is, like many estate planning concepts, a living, breathing, evolving process that is designed to help. It's not designed to be a penalty or something that's restrictive.
So as the child is growing, if you see that there's these changes that might be beneficial, how difficult of a process is that? It sounds like the initial buildup of getting a conservatorship in place can be potentially a hefty lift initially, but once it's already in place, is adjusting it just as much work, or is it a little bit easier after you have one in place?
It's a good question, and this is where I get to give the fun lawyerly answer of it depends, right? It depends on the circumstances. There could be little things that just might need a tweak here or a tweak there. There could be more, what if you go the opposite route and you have a limited conservatorship on day one, but all of a sudden things change and now you need a general conservatorship? It may be that all of a sudden we need to get medical evaluations and things of that nature, where it becomes much more restrictive and overbearing to a certain degree. So it could be a heavy lift on, that second go around or third go around, or it could be something easy. It truly just depends on what the circumstances are. And look, the world we live in now is very complex. We have a lot of family dynamics that are going on. We see it a lot. I do a lot of litigation, and unfortunately, you see, with a lot of the questions you're asking, how people are getting taken advantage of, and these things happen. It's unfortunate, but that's why we have courts and we have these processes to try to protect from it. But it's something that needs maintenance to avoid all of those issues.
So you mentioned a little bit about how the court will kind of like check in just to kind of make sure things are going smoothly. Is that something that is like automatically done as a safeguard for the autistic child or adult? Or are there things that have to be kind of like manually triggered in order to protect them?
I think in most jurisdictions, you will have a formal process where there is some periodic check-in, again, depending on the individual and what level it is at. But there are certainly going to be reporting requirements. And maybe based on those reportings that are happening, whether it's an accounting or an inventory of certain things or behavioral, reportings, based on those, they may trigger different items and responses from the court.
Okay. And this question just kind of came to me randomly, but just out of curiosity, what happens if you're responsible for that conservatorship and then you suddenly pass away in like a car accident or something? What happens to that?
I think that I have seen two, I would say, usual responses to that. One is sometimes there can be joint conservators, if you have two parents who are co-parenting in a situation like that. So if one passes away, you may have a survivor be able to take over and be the sole conservator. Sometimes you have a situation where if maybe you have a more elderly parent who is taking over as the conservator, the court may, in that initial proceeding, appoint a backup. Maybe it's a sibling or something like that, a third party. The other is you have to repetition. If you only have a single individual who's serving as conservator and there is nobody else to take over, I think in the jurisdictions that I deal in, it's typically a petition that would need to be filed to establish a new conservator, a successor.
Okay, that makes sense. So there's some financial aspects to this as well. So I was wondering, what are some key considerations for long-term care and the financial planning as part of that conservatorship process?
So this is the part that can reach all the way back to early estate planning as it goes into it. And it doesn't mean that an individual needs to set up a separate special needs or supplemental needs trust from the beginning. But what it means is any good estate plan starts early and grows and grows and grows with the family. And so you have to have those mechanisms in place that if something were to happen to a parent, for example, where the source of finances may be coming for someone who maybe isn't going to have full-time employment and maybe is going to be fully dependent, you're going to need those safeguards in place through trust planning that provide for the right management of these finances long term. And whether that's more discretionary or whether that has many more restrictions on it, that all starts with the early estate plan, because someone subject to a conservatorship, that individual is likely not going to be able to do their own planning. And so if the right mechanisms aren't in place from kind of what I call the core or base plan from the parents, oftentimes you're going to have to get court approval. If someone inherits, say, $1 million and they're subject to a conservatorship, that conservator, assuming that it doesn't get eaten up by medical expenses or public benefits that they may lose if they're on them, certain things like that, you may have to go back to the court, which we often see, and say, hey, court, please allow us to do certain estate planning to put this money in a trust or put it in certain accounts, again, depending on the jurisdiction you're in. There's certain bank accounts you can use. So oftentimes it relates all the way back to the original estate planning coming from parents and grandparents to have the right safeguards in there for that supplemental needs trust, which is tricky in and of itself. But then there's also the component of if someone comes into assets, they may need to go back to the court. Again, it may get detailed in one of these accountings or a report, and they may have to ask the court for special permission to use a trust. Or certain jurisdictions have different programs that you can put the money into, like a pooled trust or certain other special trusts that maybe pay back medical care when the person dies and then it can pass on.
Yeah, that makes a lot of sense. It's really a lot of planning that goes into it that you don't even think about until you have to do it. Then you realize I should probably hire someone.
It's certainly one of those areas that we're usually, as I joke, we're usually last on the list of who everybody likes to call because of what we do for a living, but sometimes it can be the most important.
I was about to say, I feel like you should be on the top of that list.
The pandemic changed that a lot.
Really? Like you got more interest post-pandemic?
Absolutely. Yeah.
I guess
any sort of health scares can really put things in perspective for people. And, you know, at our office, we were out at picnic tables outside doing signings, sometimes 10 a day for different estate planning documents.
Wow. Yeah, that does make sense. So one of the things that I'd like to ask you personally, just based off of your experience and the feedback that you've heard from parents that you have worked with, what advice would you give to parents, particularly my parents out there listening, who are just beginning to explore the concept of a conservatorship for their autistic child?
So I think that what is important in this area in particular, as you've kind of noted, and as we all who do this for a living feel, is there are so many little twists and turns to how this kind of takes shape. You have to have the right team around you. And we all like to have resources where we can do it ourselves nowadays and look up how to fix this and fix that. I would urge everybody to put the right team around you, whether that's a lawyer. Usually I like to look at a lawyer, an accountant, and a financial individual to put that team together to get the right advice. And I think that applies here as well, as start early with that team and put the mechanisms in place and get the right advice to try to plan early for these things and understand that it's not going to be a set it and forget it or one size fits all type approach, that if you sign documents on day one, don't let them go 10 years without looking at them. You have to have these conversations early and often, and especially with individuals with autism, it's such an evolving dynamic, diagnosis oftentimes that what you get on day one could change on day 3 and so forth. And so you have to have these conversations early and often. Again, if the individual is high functioning and can have an understanding that they can demonstrate, having those family meetings with the attorney so they can put a face to a name and have a resource to go to, it's super important. I can't stress enough that if you can have conversations and meetings to allow an individual who's going to be the subject of this, who may be 18 or 19 or 16, knowing that they may have this for the rest of their life in terms of a conservatorship arrangement, having these conversations to allow them to see it's to help. It's not to punish. It's not to take things away. It's to set up the right building blocks for you to be independent, for you to be able to live life on your own with that conservator in the background to help. And I think that's the most important foundational piece to set with a child that's going to transition into this at some point.
So something that I heard you say multiple times, which makes me think is very important, is the word early. So what does early mean? When is early? What's a good time to start looking into this? Say your kid just got diagnosed, they're 2 years old. When would you start looking into this?
It's never too early is the answer. I think that there's usually two key times when people start really looking into estate planning. It's the death of a loved one and the birth of a child. Those are two very key times. And so if you have a young child and you get this diagnosis, I am a big believer that it cannot hurt to pick up the phone and have an initial call. You may have an initial call and then you hang up and that's that. And you get the information, you've done your due diligence and you feel good about it. I don't think there's anything wrong with that. So when I say early, it's as soon as you are focused on it, maybe you already had an existing estate plan, now you've had a child, now there's a diagnosis. Pick up the phone, send an email, whatever it might be, to your advisor and say, what does this change? What should I be thinking about? And I'm a big believer in lists. And so make a list of those concepts and the thought process. And it may not be something you change on day one, but it's just some things to think about as life evolves. And so, yeah, the concept of early is super important.
Well, this has been really informative, Adam, but I've got a couple more questions for you before we wrap up. One of them is one I like to ask all our guests. Our podcast is called Embracing Autism. It tends to mean something a little different for everyone. So I wanted to ask you what your take on the phrase embracing autism is.
I thought a little bit about that in advance of this. And to me, I think what it involved is being able to support individuals with autism to live life to the fullest and to promote independence to the greatest extent possible.
Absolutely. That's what we're hoping for our kids. Are there any additional resources that you can share with my audience or any information that you'd like to share with them?
I don't have any resources at the tip of the tongue other than I think that looking to your local communities, there are a lot of good support groups and things of that nature that have, the right legal individuals that you can go to. I think if there's ever a question and you need a lawyer, word of mouth is a good way in your community to find those individuals that specifically do these types of legal frameworks for people. And I think talking to your local bar association, or even you can call the trust department in your local circuit court, they can be good resources. But putting that team around you, reaching out to your financial advisor, reaching out to your accountant, they're going to have the right resources for you.
Is there a specific name to like the type of lawyer or anything? If they wanted to find the right person to do a conservatorship, who would they be asking for?
I would start with someone who's involved in trust and estate work, estate planning, or sometimes even family law. Those practice areas mean a little bit different to each individual, but that's where I would start. Certainly, anyone who calls our estate planning group, if we can't help them, we have the right resources in the local community who can. I think also if you're involved with any sort of social workers, they should have a good resource as well. And I think they are a good resource for these types of referrals.
Awesome. Well, thank you so much for joining today and sharing your expertise. Before I let you go, where can our listeners reach you if they have any more questions or if they need assistance with estate planning or a conservatorship? Do you have an online presence?
Sure. We have a website. It's www.steinsperling.com. And my email address, I'm happy to give it out. It's Abramowitz. So it's AABRAMOWITZ at steinsperling.com. But you can find me right on the website. I am happy to talk to anyone that has questions. Like I said, the first step is reaching out and having that conversation.
And we will include the contact information in the description for those of you listening or watching so that you can find them. So thank you so much for joining us today. This was really helpful. I know that Matt and I are definitely looking into something like this. I feel like we're a little bit overdue. So this was really helpful for us. I appreciate you taking the time to talk with us.
Well, thank you for having me.
Have a good one.